Well, welcome everybody online to this Garden Court mental health seminar. It's billed as a mental health law update, but in fact the speakers that we've got are going to speak about a variety of different and very important things, some of which are going to be in the future, because they include things like the proposed reforms to the Mental Health Act and what Mind has been saying about that, how people can participate in trying to develop the law with test cases and so on, and also the first talk that Roger and I are going to do on where's the mental health tribunal going. So these are all things that in a sense are not so much an update, but looking ahead. So you get double the value for logging into this seminar. So welcome everybody. I'm Stephen Simblet. I'm a barrister at Garden Court. Speaking this afternoon will be alongside me Roger Pezzani, who's also a barrister at Garden Court and who many of you I hope will be familiar with. He practices exclusively in mental health law, representing patients and advisors, patients at all levels, from hospital managers hearings to the Supreme Court, and as many of you will know, has been in many of the important reported and appellate cases that have established important points of law. Then we're going to hear from Rheian Davies, who is head of legal at Mind. She spent 15 years working as a psychiatric nurse before qualifying as a solicitor in 2006. She worked in a variety of firms, including her own firm, and in private practice has conducted many groundbreaking mental health cases, often alongside Garden Court barristers. And she was Legal Aid Lawyer of the Year for her work in mental health law. She's currently head of the legal team at Mind, which you will, I presume, will know is the UK's largest mental health charity. And then Alice Livermore is going to be our final speaker. She's a senior lawyer at Mind, specialising in the rights of children and young people. She's also on the Law Society's Mental Health and Disability Committee. And before she was at Mind, she also worked in a legal aid firm for 8 years, specialising in mental health, mental capacity and community care law. So people who know things about things. I'm going to introduce the topic that they'll speak to just before the people do it. But there's a few bits of general housekeeping and rubric before we start off. There's some meeting chat which gives us various instructions and so on in relation to the meeting. Chat is designed for chat amongst yourselves and ourselves. Any sort of questions and so on would be better to put in the Q&A, and I'll try and have a look at the Q&A as we go along and see if there are any questions that either can be answered in writing or to have a think about who might best give an answer to those. We'll try and deal with as many as we can. The seminar is being recorded and is likely at some point to end up may end up at some point on Garden Court's website or something like that. So if there's anything you're particularly sensitive should not be disclosed to the wider world, be careful about that when either asking questions or putting things in the chat and so on. Also there is CPD for those that want it through the usual ways. We are an accredited provider, and you can put down that you attended this if you want CPD points. I hope that's sufficient introduction. I'm going to, Roger and I are now going to talk on our thing, which is where's the mental health tribunal going, which mainly Roger is going to speak to the slides that between the two of us we produce, mainly his slides, mainly his work, and he had in mind that he was going to talk and we'd sort of discuss it, and there'd be an avenue of disagreement as we went along. So it's rather like Waldorf and Stadler, or a sort of grumpy version of the two Ronnies as we go through this thing, but actually on an important and interesting topic about how in fact the Mental Health Tribunal is going to tackle the issues around restriction of the discharges of people who are subject to restrictions on liberty, and also overlays with the Court of Protection. So what I'm going to do, we've got a slideshow. I'm going to start our slideshow, share the screen, and if somebody can confirm that they can see the slideshow when I think it's there, then that would be helpful. So here we are, slideshow. And I'm going to share the screen, I hope. No, I'm not. I'm going to share my screen first and then slide this. I've done this before, so then start first. There we go. That, I hope, it says I'm screen sharing this screen, and I will start the slideshow from the first slide. I hope, yeah, there we are, that looks better. So, where's the Mental Health Tribunal going? Let's move to the next slide. You can see Alice peering down the rabbit hole, ready to find out. And well, Roger, do you want to start off with speaking to this slide, which also allows Roger to play the role of Chris Whitty, with me as a befuddled Boris Johnson, as he said after he says next slide. So, Roger, you start.
Okay. Hello, everyone. I don't know who I'm talking to. So, if you don't know me, as Stephen said, my name is Roger Pezzani. This is something that kind of I think I've spoken on before to the MHLA, or possibly to an MHLO seminar we did a while back. But it's kind of important and fundamental. So I'm going to speak on it again. Stephen, I don't know what that big black spot is on the slide. Do you have that?
Yes, I think it's part of the slide.
Okay. Maybe that's the hole that rabbits that Alice,
I think it's part of the slide.
The previous one. Yeah. Okay. Okay. So why is the MHT changing? It is changing. We're still in the early stages, but that doesn't mean that it isn't already changing, and changing potentially fundamentally. As I say in the slide, it's in the longer term. That's because of, well, many of the proposals in the new legislation, if it ever actually becomes legislation. But one of them is that it will allow the tribunal to authorize what's called supervised discharge for restricted patients. And what that means in a nutshell is that the tribunal would have the power to authorize a post-discharge DOL. What they say in the white paper is that this would be irrespective of decision-making capacity. It would lead to an annual review by the tribunal in line with the Court of Protection decisions on similar cases. And they say it would be closely monitored to ensure that conditions amounting to deprivation of liberty were only applied when necessary and proportionate, whatever that means. But also, it would only be applicable where the patient is no longer therapeutically benefiting from hospital detention under the Act, but continues to pose a level of risk which would require a degree of supervision and control amounting to deprivation of their liberty, and so could not be managed via a conditional discharge. The bit about no longer therapeutically benefiting from hospital detention under the Act is peculiar. For anyone that regularly does mental health tribunal cases in the tribunal, you'll know how easy it is for doctors to describe what's being done as treatment and how the patient is benefiting, perhaps not today, perhaps not next month, but at some point, and how difficult it is to argue against that. You know, appropriate treatment, treatability cases, they hardly ever win, and they hardly ever win for a reason. So it's there, but putting a sort of no longer benefiting therapeutically condition on it makes me wonder if that stays, and if it stays that way, how useful it's actually going to be. But anyway, the thing is, the tribunal can kind of do that already, even though the tribunal and everyone else has to pretend basically they're not doing it. And that continues to cause confusion and perplexity. Can we have the next slide, please? Okay, so this is a bit of just anecdote, really, from my experience. But there is one judge, who I won't name, who, at least as far as my experience is concerned, starts every single restricted case with one question, which is, has the patient had unescorted community leave? And if the patient hasn't, then you may as well just walk out. You're not going to get discharge. I set out on the slide relatively obvious, I think, problems with this approach. The main one, if I can just summarize it rather than reading out the slide, which is boring, is that if a patient's practical right to discharge depends on that patient being given unescorted community leave, and given is the right word, because the only person that can give it to them is the RC in collaboration with the consent of the Secretary of State for Justice. If the patient's right to discharge depends on that, then what it comes down to really is that the patient's right to discharge is dependent on the exercise of discretion by the responsible clinician and the Secretary of State. Because if they say, well, we don't care what anyone else says, we think that you're too dangerous to have unescorted community leave, the risks are too high, so we're not going to give it to you, then if you get, well, whatever judge you get is going to make your case for discharge much more difficult, because all tribunals are naturally going to be nervous about saying somebody that can be released into liberty when they haven't been tested on unescorted leave at some sort of liberty first. So it makes it more difficult. And the 1, 2, 3, 4, 5, 6th bullet point is relevant here, because relatively recent case law that went up to the Court of Appeal in the YZ case, which was heard by the Lord Chief Justice at the time, has made it clear that the Secretary of State and responsible clinicians have a very, very broad discretion when it comes to making decisions about transfer, but by analogy also about leave. So if you haven't been given leave, unescorted community leave, because either the RC or the Secretary of State or both say that you shouldn't have it, you're going to really struggle. It's not impossible, but you're going to struggle to get a conditional discharge from the tribunal, but you're also going to struggle to get that decision overturned, for example, by judicial review. And so courts and tribunals often are of what I've said, no use, limited use at least, to restricted patients who want their liberty back without having leave. But following the fallout from now unescorted leave may not always need to be a precondition to discharge. And the basic reason for that is because you may not be going into a situation in which you will be unsupervised. In other words, you may be going into a DOL. And now can we have the next slide, please? Okay, I should say that it was my responsibility to, well, it was my choice to choose these pictures. If this picture doesn't make sense to you already, it will in a minute. But it is at the moment all about ducks and hats and possibly signets. Next slide, please. So here's the reference to signets. This case is a good one. Make a note of it, or I don't know, copy and paste if you can, or whatever, if you don't know it already. As I say, it didn't create new law, and I've said it's useful because it summarizes a line of authority that emerged after MM and endorses it. But what it also does, essentially, this is the upper tribunal Judge Jacobs, kind of doing all of your work for you in relation to the lawfulness of DOL conditional discharges. It's quotations from lots of cases, from the relevant parts of lots of cases, a little comment on each of the cases, and then a summary of what those cases in total mean. And it's really useful, and it's for any case where a DOL conditional discharge even might be an issue. it's a case that you should always have in your back pocket. Obviously, it's an upper tribunal case, so it's binding on the first tier tribunal. But it's also useful just as an explanation of how it might work, both in law and in procedure. And it's a good one. In a nutshell, as I say, it says that the principle that a DOL conditional discharge is lawful as long as the DOL is authorized is correct. The question is, how can it be authorized? Because the tribunal, as we know from the MM case in the Supreme Court, cannot lawfully authorize the DOL. In practice, what this means is that if a patient A has escorted leave, B, and all is going well, B, the patient lacks capacity to make decisions about what's needed to manage the risks he's assessed as presenting, then C, it's arguable that he's entitled to a DOL conditional discharge, even if he hasn't had and never will have unescorted community leave. So strategically, it's useful in that in some cases, it cuts out that obstacle that's presented by the need to have the Secretary of State and the responsible clinician agreeing that the patient is entitled to or ready for unescorted community leave. It skips that step. This is in relation to restricted patients, but I don't see why the same principles couldn't apply to unrestricted patients as well. If the COP can authorize a DOL to run alongside a conditional discharge, why couldn't it authorize a DOL to run alongside a CTO or a guardianship, or to run alongside nothing other than a patient entitled to aftercare? I don't see a reason in principle why that couldn't happen. In relation to CTOs and guardianships, obviously the tribunal can make recommendations in relation to those, but its powers are limited, so you need to look at potentially other avenues than the tribunal. But this is the basic principle, and it's all explained there by Jacobs in Signet. Really the most useful case of the last 3 years, I would say. Next slide, please. Okay, I put it, there's loads of text on this slide, and I'm not just going to read it all out, but I put at the top, this is where it gets tricky. I think it gets tricky if you look at the sort of the longer view at what's really going on here. Of course, many patients are assessed as not understanding what's needed to manage their risk. Are assessed as not understanding or being able to acknowledge, the language varies but the meaning is the same, the risks inherent in them being released. And you might even say, I've said that a tribunal's asking a tribunal for discharge against the recommendation of a clinical team, by definition, at least doesn't agree with the clinical team about the risks are, and so in the clinical team's assessment is going to say that they're wrong, and so the clinical team would say that they don't understand it, that they themselves are right and that the patient is wrong. So what this comes down to is the usual old argument about insight. Clinical team, the patient doesn't have insight. Patient doesn't have insight into the need for him to take medication, doesn't have insight into the need to stay away from this particular area, blah, blah, blah. Most of you can probably write that script. It's a very common one. There are interesting questions about whether there is a difference between insight and capacity, and if so, what they are. It's been addressed, but imperfectly, in various academic papers, and there's never really been a proper resolution of it. The most interesting paper, which I should have put in the slide, but I forgot, it's a really interesting paper to do. They just searched a huge number of Court of Protection judgments for the word insight, and literally, Control plus F, and then just sort of assessed, what was said about it and whether it was said in each of those instances to be different from capacity or the same as capacity, and lack of insight equals lack of capacity, and so on. But the answer was completely inconclusive. It's like sometimes they say it is, sometimes they say it isn't. So, and that's the Court of Protection. Obviously, we don't know because that research can't be done in the first tier tribunal. But it does seem to me that in some individual cases, at least, and possibly in many individual cases, it's possible to say that a patient who does lack insight into the risk And if you lack insight into a risk, then you also lack insight into how it needs or should be managed. Will also be assessable as unable to understand the information relevant to the management of that risk, and or unable to retain or use or weigh that information when making a decision. And so, if it's arguable also that it's in his best interest to be supervised after discharge, and see paragraph 22 of MC for that, then you can argue that there should be a discharge into a DOL CD. And it's becoming increasingly common, particularly for patients who are diagnosed with learning disabilities. But, and this is where I'm starting to get a bit more controversial, I really do not see why it couldn't apply equally to patients with schizophrenia or dissocial personality disorder, for example, or bipolar disorder. Particularly, as some of you will know about, there are increasing numbers of quite elderly men now who are usually detained have been detained for decades, have progressed as far as they can, which is usually to a long-term, relatively low secure, often, in fact, almost always private PD hospital, private PD ward, and they just stay there. Sometimes they're transferred to private PD wards in the middle of nowhere, not near any town and things, with the specific idea that because they're in the middle of nowhere, they can start to be tested out on unescorted community leave. But very often it doesn't happen, because when the new RC looks at and assesses the risks, essentially the RC says, there's no way I'm giving this man unescorted leave, the risks remain too high. And so the patient is stuck, gradually seeing out their days in a low secure PD specialist hospital in the countryside somewhere. The thing is, again, this is just my experience, it's only anecdotal, but a lot of these patients appear to have had escorted community leave for a very long time. When they're out with one nurse, it's usually sort of one escort of either gender, they don't offend, and that's been going on for years. The problem is this hurdle that I was talking about of the SSJ and the RC refusing unescorted community leave. Why couldn't this apply to them? If these men do not understand the risks that, or do not accept the risks that they are said to present to such an extent that it has kept them in detention for years or decades, despite years and decades of treatment, at what stage do we say that that lack of insight amounts to an inability, an incapacity to understand, retain, or use or weigh the information that is relevant to the management of their risks? But there it is. When it does apply, I think the way of arguing that unescorted community leave no longer is a precondition to a credible application for discharge, it is simply to say that there's no need to do a dry run before discharge for something you ain't planning to do after discharge. And so this is all quite new, and the MHT can't sit back on the usual way it's been doing things. Next slide, please. And the problem is that, again, this is my experience, but some tribunal judges find this new approach troubling. It means they have to change the way they approach cases. It's not so easy to trot out the same old easy reasons for refusing discharge. And in my personal experience, I've seen two cases where we ran a dull conditional discharge argument with supportive evidence from the responsible clinician in both cases saying, yeah, I'm absolutely convinced that this man does not have capacity to make these decisions about how his risk needs to be managed and whether he needs to be supervised in the community. And I'm convinced that he's perfectly safe when he is escorted. And instead of dealing with it, in two completely different panels of tribunals didn't even mention it at all in their reasons. They found it so upsetting. And obviously that leads to an easy appeal, or not even appeal, it's just a review. No matter how carefully you explain it, it's troubling to some tribunals. Some are all over it. But there are others, perhaps the ones that have been doing the same thing in the same way for many years, that struggle with it. And so we're, asking them to examine unfamiliar concepts, capacity, best interests, and really interrogate what, as I say, the old cliches about insight means. And then there are the procedural complexities, which are a nightmare. The tribunals don't like it, and to be honest, neither do I. Next slide, please.
Can I just chip in there that
Yeah.
I mean, we need to go back to the ducks and the hats, because the MC was a way in MC, Judge Jacobs set out two different methods of trying to achieve this, either combination of adjournments, which is getting ducks in a row, or wearing two hats, which was sitting
Stephen,
both in the tribunal and in the Court of Protection. The next slide, isn't it? So there we go.
That is literally the next slide.
It is, isn't it? Yeah, sorry, I knew it's I've spoiled Roger's thunder. I just wanted to show the slide with the hats and the ducks on it again.
Spoiled everything, and now I'm going. Yeah. Well, I mean, here we go. I mean, this is ducks and hats. The problem, and I mean, if this is downloadable, there's no, we haven't got time, and I'm not just going to read all of this out. But it's an example of how ridiculously confusing and uncertain all of this still is, because this is all still new. People are still trying to work out how best to do things. There's been some litigation about it. There will undoubtedly, I would bet the farm that there will be more litigation, and a lot more litigation about whether it should work, and if it does, how it should work. But at the moment, what we've got is Judge Jacobs' comedy analogies. As Stephen has said, ducks in a row and different hats. Although even the judge that invented those analogies got confused by them almost immediately, and by in the next paragraph referring to the approach as the same hat approach. So, I mean, the whole thing is just a mess. And, it's jurisdictionally problematic. It's problematic in relation to costs. This is a little bit in the third thing is worth just pointing up. In the tribunal, you have non-means tested right to legal aid. In the COP, you don't. You got to pay, or someone's got to pay. And there are patients with meager savings, but not meager enough to qualify them for a legal aid certificate. If they don't want to go and pay for that, and if the local authority and the health authorities don't want to go, then how is it even going to get into the COP? And if it doesn't get into the COP, where does that leave us? The case is just in limbo forever. In limbo, that's a familiar phrase in mental health law. It takes us all the way back to H in 2001, where the position of patients who were just stuck with a deferred conditional discharge that was never going anywhere was found to be in breach of Article 5. And I wonder whether that's where we're heading again with this procedure, for various reasons. Yeah, I mean, these applications are becoming more common. The problems will become more common as well and more acute. And I say there it arguably violates Article 5.4. The further complication, which is the long last paragraph on that slide, is, oh my God, what happens when it isn't a Section 73 case, but a Section 74 case, where you've got to imagine all of the theoretical possibilities of going to the COP and getting authorization and then coming back to the tribunal. And then you've got to go through the whole exercise again for real. If you do get something from the tribunal under Section 74.1, you've got to do the whole thing again for real in front of the parole board. And as far as I know, the parole board has never once been asked to consider this. They should be, because the principles are the same and the law is arguably the same. If you can have COP authorizing a dole to run alongside a conditional discharge, why can't you have the same thing happening to a conditional release of a prisoner? I don't understand why not. Anyway, as far as I know, it's not been argued. Next slide, please. So, and this is just like blue sky thinking. I mean, some of you are going to find this boring and annoying. I hope at least one or two of you might find it interesting. But this is, I think, getting to the heart of the problem. I'm not sure it gets to the heart, but it's on its way. It's got to be acknowledged that this is a horrible mess at the moment. Jurisdictions fighting with each other, the potential for the Mental Capacity Act basically to eat everything that the Mental Health Act is doing or tries to do. And you've got to ask, well, is there something more deeply wrong here? And I think arguably there is. Of course, the vast majority of people who are detained in hospital are manageable if they're supervised 24 hours a day, because that's why they're detained. But if one reasons from the principles in these recent authorities, it's possible to envisage huge numbers of such patients being entitled to such a discharge because they lack insight into what's needed to manage the risks. I was asking questions of a responsible clinician in West London in a tribunal last week and put these principles to him. And he said, yeah, totally, I see what you mean. But if you want to do that with this patient, I've got 3,000 other patients that we could talk about as well, because it would apply also to them. And he was right. But then it gets worse, because we know from research that very large percentages of prisoners are suffering, or diagnosable at least, are suffering from personality disorder. So I used the example of a burglar who gets convicted, gets put in prison for a while, gets released, does another burglary, and so on. Those of you who are familiar with the ICD-10 or the DSM will see how easy it would be to make an argument that that person suffers from dissocial personality disorder. Well, if that's the case, could you not say, well, if this burglar is supervised 24 hours a day, his risk could be managed? And he does suffer from a mental disorder because the ICD-10 says so. He's got a dissocial personality disorder. So why couldn't he be released in this way as well? And so the MCA starts to overshadow prisons and the criminal justice system as well. And the whole thing just becomes absurd. As an example of how absurd it could become, think of the buildings and the resources that would be needed. We would end up with almost every patient and prisoner being gobbled up by the Mental Capacity Act. And we then need to find buildings in which all of these people could be supervised 24 hours a day. And those buildings, as I say on the slide, would look very similar, some might say identical, to hospitals and prisons. And so the circle closes. The problem is that none of this has yet been resolved. Almost all of the principles and propositions that I've set out here either haven't yet been properly tested or haven't been tested at all. But I think that the logic and the principles demonstrate that they can and probably need to be as well. Next slide, please. Okay, this is kind of where Stephen takes over, and you get to stop listening to me. This is kind of the current situation with patients with capacity. Stephen knows more about it than me. I'll just introduce it by saying there was a time when there was an authority upon which one could say that somebody who lacks capacity, somebody who had capacity that could make a choice about whether they wanted to be supervised in the community could be dealt with by an authorization under the inherent jurisdiction. That's now very doubtful. Stephen, do you want to take over?
Yeah, I mean, there's not a great deal more to say about this because it is a mess. I mean, as everyone knows, the decision of the Supreme Court in MM, while sort of reasoned from a sort of position of logic, creates for a number of people what they see as real difficulties in actually facilitating the discharge of people who require some supervision, but where the degree of supervision that they require has to stay the side of the line of not being a deprivation of liberty. And there's been a variety of cases looking at that problem. And indeed, in the third bullet point, a health and social care trust against Mr. O and Mr. R was a decision that I was involved in, asked to act for the Northern Ireland Human Rights Commission, who intervened we only intervened in writing in this case, in a decision where the people bringing the application had been there was a variety of cross applications, including applications for habeas corpus, applications for declarations that the current that arrangements that would put into place a conditional discharge ordered by the Northern Ireland equivalent of the Mental Health Review Tribunal, and various other applications as to the declarations as to the legality of arrangements that amounted to a deprivation of liberty, were all being considered by a judge in Northern Ireland in circumstances where essentially she could reach no proper conclusions. And so essentially what we ended up with in that case was her sort of adjourning things for further evidence and bemoaning the fact that this whole complex situation of people who may be thought to pose some sort of risk. I mean, one of the claimants in the O&R case was a child sex offender who there were particular concerns about the ability to supervise him. Essentially the tension between ensuring that there is a fidelity to the decision that the patient has obtained, namely that he be discharged, yet there being a safe system of support for him in the community, and the entirely unsatisfactory effect of that support system delaying the discharge that he's got. I mean, essentially, the judge became concerned that you end up in a situation whereby affording the patient his discharge, but only when the conditions are put into effect, you create all the problems that we thought we'd got round in these cases on conditional discharge on conditions in the past. So essentially, this is now a mess. There is there is also a difficulty and a further discrimination and problem between patients who may lack capacity and those who are carrying around their finding that they do lack capacities. The whole thing, both in terms of the ability to implement faithfully the decision that the tribunal has ordered, the requirement that patients receive the aftercare that they are entitled to, and the whole going back to the problem that we often used to get with a responsible clinician refusing to be the supervising responsible clinician in the community because he or she did not think that the discharge conditions were sufficiently robust. All of that coalescing in a set of interrelated problems overlain by issues of it being different whether the patient has or has not capacity, and the statutory presumptions that patients do have capacity unless capacity is proven not to exist. So all the Northern Ireland case that I've cited there is just cited there not because it's an example of great jurisprudential reasoning, but essentially as an example of all the problems that arise and the real difficulties for judges in trying to resolve those, whatever hats they're wearing, whatever ducks they have in a row, and whatever the support packages or otherwise there are. So essentially we end up with, as Roger has summarized the position in the last 2 bullet points on this slide, that the patient who asks for close supervision after discharge can't have it, but if he doesn't know that he needs it and would object, then he can. And this is just, where an example of exactly how the colonization of the mental health tribunal law by what goes on in the Court of Protection and the principles under the Mental Capacity Act is going to cause all sorts of problems and litigation in the future. It was thought that this Health and Social Care Trust was going to end up being appealed to the Supreme Court, and certainly some of the other parties were seeking to do that. But in the end, the judge just fudged it all, reserved it all, and has kept it sort of under continuous review, expressly saying and explicitly saying how concerned she is for the protection of the patient's Article 5 rights while all of this continues. So, you know, it is a mess, and as Borat would say at the bottom, think makes perfect sense not. So I'm going to move to the next slide. And this is and again, I think we've both got something to say about this, because this is the extent to which people think they can invoke the inherent jurisdiction to resolve some of these problems. And Roger had drawn my attention in and this is summarized in the first bullet point, to something that Sir James Mumby was saying in his lecture to the Court of Protection Bar Association about the limits on the inherent jurisdiction. And one of the things, and many people will have this in mind after the prorogation case, was the de Casa principle, where in relation to prerogative powers, if there is a statutory scheme that impliedly abrogates the use of the prerogative, and the same has been thought to apply in relation to the use of the inherent jurisdiction. However, relatively hot off the press, and within the last month or so, the Supreme Court has finally given its reasons in the decision Re Tia Child, which essentially, well, can be summarized in its main finding that it is lawful to accommodate children in secure accommodation that doesn't meet the regulatory brackets, i.e. imposed by statute, requirements in relation to that accommodation, if the arrangements are necessary for the protection of a child against, as the judge used, the risks of the gravest kind. So essentially, even though there is a detailed statutory system by which it is legal to accommodate children in particular approved and regulated accommodation, and illegal, and I don't just mean unlawful, but I mean illegal, because in certain circumstances it's a crime for the operator of these homes to place a child in it if they don't have the necessary approvals. Even with those problems, it is nevertheless a lawful use of the inherent jurisdiction to do so. If the court decides it's necessary, I'll go there because there is nowhere else. Now, obviously, that was a case about children, not about incapacitated adults, and it is a case in which there is a statutory duty under Section 25 of the Children Act to accommodate children that don't have any accommodation. But nevertheless, the fact that the Supreme Court held that not only is there jurisdiction, but on the facts of that case, it had been lawful to use that jurisdiction to accommodate a child in circumstances where people could be committing a criminal offence, shows that the neat idea that if there is a statutory procedure covering this, that the inherent jurisdiction will not be available, simply it does not pertain. However, this case does need to be read with a big caveat, as summarised in my bottom point there, which is this issue about whether the inherent jurisdiction was available at all had not been run either at first instance or in the Court of Appeal. So the arguments were being sort of dredged up before the Supreme Court, who were somewhat unsympathetic to hearing them at all, and commented that it was all somewhat hypothetical, not least, in fact, because by the stage of the Supreme Court, Tia herself was no longer a child. So, it was they lacked the sort of quality of factual findings that they might normally have wanted. But that's where all of this is going. There are real problems for the rule of law and for the idea that Parliament is going to legislate in this area definitively. So that's our last slide. I'm going to stop sharing there and come back into the virtual room. I think it probably we'll take questions. There's some in the chat and some in the Q&A. I'll have a look at some of those. I think it probably makes sense now to hand over to Rheian Davies. I've introduced who she is. What she is going to tell us about are the proposals for the new Mental Health Act currently making its way through Parliament, and in particular what Mind has said about the various proposals. So I'm going to hand over to you there, Rheian.
Thank you, Stephen. So what I'm going to talk about is the Mental Health Act review and the white paper that we've been asked to comment on. This is long overdue by at least 2 years, but obviously other problems have been troubling the country. Last we were told is that a draft bill might be by Matt Hancock, is that a draft bill might be before Parliament by the end of the year. But I would say watch this space in terms of dealing with that. So what Mind said is that we welcome the draft, the white paper and its tone and its aims overall, but we still have some concerns about things that have been left in the scheme and chances to reform that have been missed. Particularly with the disproportionate use of the Mental Health Act for the Black and ethnic minority populations or racialised communities, particularly Black men. And I'm going to talk about some of the structural racism which is built into the Act and some which is more to come. Many will share the view that the old Act is now really well outdated, and we think that one of the good things about the white paper is that currently people have very little say in all their care and treatment under the Act, and sometimes it's trite to say that they're one of the most powerless people that you can meet are people who are detained under the Mental Health Act. The reforms have given greater weight to people's wishes through advanced choice documents where people can set out their wishes about future care and treatment, statutory care and treatment plans which are informed by the person's wishes, and another role for the tribunal in potential scrutiny of that plan. Rules for treatment and decision making, making it harder to overrule the person's wishes, and also new ways to challenge treatment decisions, again, potentially through the Mental Health Tribunal. Currently, there are much more that independent mental health advocates could do, and the reforms in the Act say that they will expand the role of advocates so they can offer a wider range of support to help people express their thoughts and wishes, and also to provide culturally appropriate advocacy so people from a range of different ethnic and cultural backgrounds are equally involved and protected. And also because this is about probably 30 or 40 years overdue, replace nearest relative with a nominated person chosen by the patient to carry out that role. We believe the Act will give greater scrutiny, transparency and oversight. I'm using greater in its literal term, but that the reforms will tighten the criteria for civil patients' detention because by narrowing the criteria for detention, and by an explicit reference to therapeutic benefits of treatment. So Obviously, the devil of that is going to be in the detail. I think the Department of Health have promised that it won't mean the old therapeutic milieu test that used to confound a number of personality disorder cases that you might run before the tribunal, where someone was on no medication or therapy, but somehow was magically treated by the environment itself. So they said it won't be that, but the detail of how that comes in will determine how they will narrow the criteria and make less people detained. There are going to be more opportunities for tribunal to discharge people and scrutinise and make changes to people's care. We very much welcome that, but there would also need to be some change in perspective and practice from the tribunal in real speak, if you want, in the way that Roger has been outlining. I suppose if I can move on quickly to some of our concerns. We, in the white paper, it talked about different reforms and then talked about them being subject to funding review. And we think that if reforms are not funded, then they are not reforms, they are a wish list, and that the government needs to put money behind everything that it says it wants to do. For example, entitlement to culturally sensitive advocacy and increase access to tribunals. All of these are going to take great resources to manage, and without increased resources, for example, with the mental health tribunal, that would just simply fall over and not function. We are also concerned that issues of racial equality haven't been adequately addressed through the Act or the draft, the white paper. For example, many of us will know that community treatment orders, we mind oppose them in any event, and we do not believe that they have reduced hospital readmissions and often experienced as intrusive and coercive. And it shows the use of CTOs has the most staggering racial disparity, with Black and British people over 10 times more likely than white people to be placed on a CTO. And the reason for this is, obviously, racism permeates throughout clinicians. People don't go to work and intend to be racist, but when they're looking at risk assessments, it's clear that psychiatrists and other people involved in risk assessments see Black people as more dangerous and therefore in more need of interventions around coercion and control. We are very disappointed they didn't get rid of CTOs because we don't believe they have a lasting effect, and they provide structure to racism within psychiatry. We were disappointed about that, but they're not proposing either to legislate for CTO to have a maximum duration of 2 years, or to change the conditions imposed on individuals. And we would like the recommendations of the review in that regard put into place. And that leads me on to supervised discharges. If people were around when CTOs were introduced, then you will remember that we were told that these were going to be for certain sectors of patients, that really hard knocks, sort of revolving door syndrome patients, they were called. And yet we found that the use of CTOs has absolutely proliferated. And in my experience of going through a tribunal, they've also had a knock-on effect of, once you get into a Section 3 tribunal and the clinical team say, oh, we're going to put them on a CTO in a couple of weeks anyway, then the tribunals seem to actually lose interest in the discharge criteria for Section 3 and think, well, that's all on its way, and off off you go. We'll rely on the treating team to manage all of that discharge when, you know, someone really very entitled to the discharge and not need the CTO. With supervised discharge regime that has been proposed in the Act for these patients who have perhaps can't get discharged because unescorted leave is considered too dangerous, but could be discharged in some community setting as long as the leave, you know, it remains escorted. Now, that's meant to deal with a tiny amount of people. I think we got one figure in one of the government workshops that said that after the case that dealt with this, that a number of people were called hospital and could not get discharged, and it was about the region of 75 people. And in our view, this you know, will again provide structure for racist thinking within psychiatry. And I think one that we'll see the same pattern as we have with CTOs, that people from racialized communities end up on them. But also part of having a CTO or a conditional discharge or something like this is obviously there's an element of people wanting to be seen to do the safest thing in terms of psychiatrists, where you've got someone who might be risky. They might not think that a CTO or anything is going to make any difference whatsoever, but think they're risky and will put them on. So they've taken every measure they can to make sure that that person is safe. And we think that will apply here, and that you'll see more staged discharges where you'll have people who are on the supervised saying, well, they can go on a supervised discharge for now, then they can go on a conditional discharge later. So we're concerned about the use of that altogether, and the possibility of providing structure to racist practice. What we're also concerned about is the proposal that the criteria for restricted patients remain unchanged, while the discharge criteria for civil patients is changed. So you're going to have one group where you've got predominantly more people from racialized communities in the restricted sector or forensic sections, having a different and more difficult criteria to meet their discharge than those in the civil sections. And, you know, we think that's probably one of the things that will be ripe for lots of lawyers' intervention if that ends up being the case. We also, sorry if I just moved to my notes. We think as well that, you know, alongside this, the resources must come, as I said, that capital funding for hospital building, which has already been allocated, is welcome, but a review of guidelines for ward requirements, for example, what they should be like and how they can be therapeutic should be part of you know, a statutory sort of framework. And just the last thing I want to go on is about the consultation on the use of advanced consent to an admission for an informal patient. This would mean that a person who lost capacity to agree to admission to hospital could be admitted on the basis of their prior consent. This makes no sense at all legally, because you don't know what you're consenting to. So you might have agreed that you should have come in hospital this time, but next time the mental health team comes around to take you into hospital, you might think that it's totally unjustified and actually not want to go and not want to rely on your own consent that you may have given 2 years ago for a situation that you didn't envisage. So that's one that we feel is really just misconceived. I mean, in terms of reforms that we would want to see, is fundamental legal rights to have services. Certainly in my private practice, a lot of my patients were forensic patients and were Black men. And when I prepared for tribunal, it was striking about how often the patient or their family had sought out care and treatment, been turned away. And it wasn't until the point that things had deteriorated that there's some kind of behavioural disturbance in public or with the family, that they get pulled into the mental health system via the criminal justice system, and the forensic admission can be their first admission, and a very lengthy and one that ruins your life chances. In Wales, we have a Mental Health Act measure that gives you a positive right to treatment. And we think that something similar could be incorporated into mental health law to stop people getting to the point that these crises happen in the first place. So that's mine's take on things. I've probably gone on for far too long against my allocated time, which I didn't quite understand in the first place. But I think I'll stop there. And I think, people will not necessarily agree with what I've said, but I hope it's a good starting point for discussion about, these patients who, really need good lawyers to stand up for them. Stephen.
Thank you very much. No, thank you very much, Rheian. That was it's very helpful to see what Mind is doing, and we're going to move now to Alice Livermore, also from Mind, who's going to tell us how we as lawyers in practice can be supported and can support Mind. And by telling us about Mind's approach to casework, the type of cases they get involved in, and the ways that Mind can support strategic litigation. So I'll hand over to Alice. Thanks, Alice.
Great, thank you, Stephen. Yeah, so as Stephen says, I'm going to talk very briefly about strategic litigation and the way Mind can support it. And just to start off, I just wanted to explain a little bit about how Mind is actually structured. So I work at National Mind, which does lots of the campaigning and awareness raising work that you might associate with Mind. But as you may or may not know, we have about 112 local Minds across England and Wales that provide face-to-face services for people living in their areas. We also have a helpline for members of the public, and that includes a legal line which provides general information on mental health law, mental capacity law, community care and disability discrimination. And they get around 1,500 calls a month on top of lots of emails as well. So when it comes to work around mental health, Mind has a national perspective, but we also have access to lots of local knowledge and expertise. And in terms of Mind's legal team, we're a relatively small team. It's myself, our head of legal, Rheian, Atif, who's one of our lawyers, and Paul, who's our team assistant. And we're slightly unusual for a legal team in that we don't represent individuals. And instead, what we do is we advise Mind on how the law applies to people with mental health problems, what we think needs to change, and how to effect that change. And one way to effect change in the absence of new legislation is through litigation and strategic litigation. And when I talk about strategic litigation, I'm talking about cases that might set legal precedent and achieve change for people in similar situations, as well as cases that could raise awareness or spark public debate. Now, I've already mentioned that we don't represent individuals, and as a general rule, but not always, we don't bring cases in Mind's name. And what that means is that we are always on the lookout for cases which other people have and might be a route to bring about some of the changes that we would also like to see. And where we do find a case we think has the potential to change the law or raise awareness in a way that would have a sort of broad and significant beneficial impact for people with mental health problems, we generally get involved either providing expert witness evidence in a written statement to the claimant or by intervening. And what I mean by that is that we apply to court to file our own additional legal arguments, generally alongside witness evidence. And thinking about how and why that might be useful for your case, well, I guess, first of all, it can sometimes just be useful to have a national charity's name associated with the case. Secondly, we've got a lot of information and expertise within National Mind that we can draw on when we put together witness evidence. Thirdly, as I've already mentioned, we've got that local mind network, so we can try and tap into local knowledge on a particular issue. And then fourthly, we have that top line data from the contacts with our legal line. And I think that can be really helpful in showing how many contacts they're getting about a particular issue, how much it's affecting people, and how that's sort of changing and fluctuating over time. And because of that local and national perspective, I think we can show pretty effectively how an issue or a legal point will affect a much larger group of people than just the individual claimant. And lots of the judgments for cases we've been involved in do mention how helpful it's been for Mind to bring that wider perspective when they're making a decision. And finally, but I think really importantly, we have an amazing media and PR team who are brilliant at getting the word out about issues that Mind are working on and making sure that everyone, and not just lawyers, can understand what the legal cases are, what the legal points are, and why they're so important. So when it comes to the types of cases that we get involved in, it's pretty varied. So to give a few examples, we provided witness evidence looking at procedural safeguards in various legal frameworks for depriving people of their liberty, and we've used that comparison to point out gaps in the framework being challenged. We've intervened and made submissions on the statutory purpose of CTOs compared to the actual impact they've had, and to raise concerns about the approach and the judgment that's being appealed. More recently, we provided witness evidence that looked at adolescent cognitive development and how it was impacted by trauma, and used that to make recommendations about the type of accommodation and support that looked after children would need. We've also been involved in lots of benefits cases, challenging regulations and processes from the DWP, often with input from our local minds who provide benefits advice. And we've been able to provide case studies of how people with mental health problems other than the claimant are being affected. We've also been able to show that the claimant's situation isn't a one-off or an example of a particularly complex individual. And at the moment, we're looking at getting involved in a case around physical activity, poverty, and mental health. So a pretty varied bag of cases that we get involved in. But we do have three sort of strategic development areas at the moment that we're focusing all of our work, including casework, around. And the first one is becoming a truly anti-racist organisation. So that's sort of work around racial justice and mental health. Secondly, supporting young people, and that has a sort of particular focus on ensuring they can access trauma-informed care. And the third one is poverty and social exclusion, and trying to stop people with mental health problems getting trapped in poverty. And also want to emphasise we're a two-nation charity. We work across England and Wales, so we're also really interested in cases about Wales-specific issues and Wales-only legislation. So I think we're either have already or we're about to put in the chat a document that has links to our casework criteria. So if you want to check the type of cases we're particularly interested in, just have a look there. I guess just flag that we are in the process of updating it. But what I would say is that we are definitely open to having a conversation about any cases you have and think Mind might be interested in. Even if we're not able to support it directly, we might be able to point you in the direction of resources or other charities that could help. And I guess equally, if you think there's a legal point that needs to get before the courts, but you don't quite have the right case for it, please get in touch, because it might be that we are already aware of individuals that are being affected by the same issue. Yeah, so if you want to get in contact with us, email is your best bet. We've put sort of a document in the chat, but it's legalunit@mind.org.uk. That will go to all of the lawyers, but I would say if it relates to children and young people, please do feel free to mark it for my attention. Hopefully that was about my allocated time slot.
Yeah, well, thanks very much, Alice. I mean, this has been a seminar with a number of objectives, some of which are actually to help people to take practical action by having good cases looked at on good facts. Because as anyone who's practiced in mental health law will know, over any period of time will know, sometimes the problem is that there is a good point, but the particular case or particular facts are not the most appealing or most sympathetic for the point to succeed on. And one of the things that I've always thought is important in mental health law is not to mess it up for other people by running cases that where you know that somebody will come along with the same point and better facts in the near future. So the extent to which people can involve Mind, who of course have expert lawyers who are aware of what other of how this issue is going to be arising in other cases is important, as much for, as it were, choosing to not run cases as it is for choosing to run them. Because if we know that there's a very good case on some of the facts coming along, we all have to be mindful of that. And I mean, this isn't talking about what either Rheian or Alice has just been talking about, but for instance, the cases on pre-hearing examinations and so on, there were loads of those and loads of separate challenges to those. In the end, how that issue got sort of dealt with was almost by the court choosing whoever had come along first, rather than actually what necessarily the most interesting or principled cases were. And quite often, as the law changes in mental health law, the changes are going to be something that affect a whole raft of people. So trying to build an intellectual coalition and a practical coalition in terms of legal resources is always going to be a helpful and important thing. Now, there's a number of things being said in the chat. One thing I should highlight is that the contact details for Mind that Alice and Rheian were talking about have now been put in the chat, so it's available there as a document, and obviously you can get it in the way that the speaker said. There's also been some questions in the.
Interrupt you, Stephen?
Yeah, of course you can. Yeah.
So the document that I put in the chat has contact details for lawyers, our case criteria. It also has our helplines. We have 2 helplines, one for general information about services and one specifically on legal issues that affect mental health clients. So not as well as mental health act stuff. So for example, they would advise on things like discrimination in employment in the context of mental health, things like, will my 136 show up on my DBS? So that's always a good resource to have if you don't want clients phoning you and taking more money out of your fixed fee, if I can put it like that. We've also got, which I'm sure we do, but it's also got our detailed response to the Mental Health Act white paper. I've given you rather a cook's tour, but it's there in detail. So if you do want to download that document and file it somewhere, it might one day be useful or not.
Good. Well, that is very helpful. Thanks very much, Rheian. I was just going to move to some of the questions and answers now. So some of there's been a variety of questions asked and answered already in writing, and Roger's been hard at work dealing all sorts of things that have been asked there. I'm just trying to look. I don't think that there are any open questions that
replies to the wrong.
Oh, right. Well, never mind. I don't think that there are any in currently sort of outstanding that as it were call for a sort of detailed answer. Does anyone else have any questions that they want to type in the chat that we can answer orally? Now's your chance.
Can I just say something rather than type it?
Please do. Yeah.
I typed something and I sent it. It's just caused all sorts of confusion. And when I typed, well, now I feel awful, that was specifically to something about fees and stuff, which only went to the panelists. I sent it out to everybody. And now people are thinking that I feel awful about things that they've said in general chat, which I'm really not. There's no need to apologize. It's all just been a complete mistake. And also thank you very much to Andy H for saying such nice things. I hope that is clear.
What he was basically, Roger doesn't charge enough money.
No, well, yeah. Roger disagrees. Also, there's a really good question from Mark Caulfield, which I haven't answered yet because, well, there's 5 open questions now. The thing is, some of these questions, I mean, some of these questions are really good, but also, in some ways, kind of, they're so good that they require some real thought rather than just a flippant answer.
The question from Mark is one that requires a very complex, that actually requires thought and a complex answer. I don't feel happy just, I mean, in a sense, he's partly answered his own question with a very thoughtful observation. I don't know if it's worth reading that out or whether it calls for any further discussion.
Well, everyone can see it. It's open in the Q&A. Yeah. And I have to say, I agree with Mark. And I agree with him about the situation that it's created. But you know, the interesting thing about that question is it's really similar. Well, it resonates with the question that Peter, or the point that Peter made earlier about the lack of effective community services. The reason why people might have an incentive to make false or incomplete assessments about capacity is because they're all snowed under and skint. And, the resources have to be figured into the problem that Mark identifies. A properly resourced sort of aftercare regime, whether it's achieved under the MHA or the MCA or both, would not or should not create such a climate of incentive and disincentive as Mark describes. I think it's a really good point.
Could I just make a comment on on some of the materials that Roger has presented, and also a question that's come in privately. Firstly, we were asked, would we get involved in sort of legal aid challenges? And that's an example of, I think often it's thought that we would just get involved in things that are direct mental health acts or protection, but we would get involved in anything that would have a significant effect on our beneficiaries. So, for example, with legal aid cuts, obviously, if our clients can't get access to lawyers or good quality lawyers because the fee's been cut so much, then that is something that we could potentially get involved in. And I think the value that mine can add is, I think sometimes the courts don't understand entirely the kind of lives that our clients lead. And our witness statements, if we do a witness statement rather than just the legal intervention, if you want, will be drawn from clients' lived experience, and we'll have lots of stats in them about their experience and how it's affected them. So it can be a sort of a valuable form of translation, if you want, in a way, to the courts about how these things really pan out for the beneficiaries. So it's not just mental health law; it's that things that can affect our client group. So we're always happy to have anything really run past us to consider. I also wanted to make a comment on Roger's point about patients who don't have unescorted leave, sometimes for years at an end. My view is that if you get around the technicalities of that, the fundamental thing is that often the RC and the MOJ do not want this person discharged, no matter what, and they will just move the legal bar again. Certainly I've had one client who had committed multiple homicides, and he was refused leave, and his doctor refused to apply, then got And he said, this is because I don't want you to go to a tribunal armed with unescorted leave. And when we challenged and made him apply, then obviously he wrote in saying, I'm asking for unescorted leave, but it's the worst idea in the world. So take that into consideration. So I think it's not so much about these technicalities, but wanting to forever detain certain patients even if they don't meet the criteria anymore.
Yeah, but I mean, that's, Rheian, I totally agree. I mean, that's my experience too. And even if it ain't the RC doing it, it could well be the SSJ doing it.
Increasingly.
But yeah. But the point is, this is a way around that, isn't it? I mean, that's the thing. At the moment, it's imperfect. It's procedurally a nightmare. It may not work, and it may not result in something that the patient might otherwise have got if they had been given unescorted community leave. But it's at least a way of addressing it that's a possibility compared to what we had before, which was basically now.
So I think that if people then start getting discharged via that the goalposts will just move.
Oh, I see what you mean. Yeah, sorry. Yeah. It would be interesting to see how. Because I mean, I guess the thing is, supervised discharge is a weird proposal in some ways, but they're kind of talking about legislating to do that in some ways, aren't they? I mean, that would be widening the goalposts if that comes through sort of in the way that it's currently drafted in the white paper, at least for some patients. I don't know. I mean, we're kind of, it's just like crystal ball stuff, this. We don't know whether there's going to be a new act, let alone what it's actually going to say anything. There we go. There's still some unanswered questions. Sorry, I'm just rambling on now. I mean, I hope Mark's still there, because we haven't answered his question in writing, but we've answered it sort of quite a lot in what we've said. Yeah. There's a question from Jay Shaw about what you said about the use of the MHA for people from Black and minority ethnic communities, Rheian, and then yeah, I mean, we're almost at 6:30. Sorry.
I can certainly address that. So I think in the first instance, having within the legislative framework, I mean, this all has to take place in the context of resources and everything. But I hope I've talked about how legislation can actually provide a structure for racist practice, and how hopefully you can turn it around, or be part of the solution and turn it around in practice. So one, I think having a positive right to mental health care would be enormously useful, so that when people first present, they can actually get help instead of being turned away and ending up in the forensic system. Obviously, initiatives like Shaney's Law and the guidance that's going to come around that in terms of monitoring the outcomes, in terms of what happens when people end up in hospital, end up in the most coercive measures such as restraint and to an extent seclusion as well. Having taking away CTOs, not having supervised discharges, and also making sure that that there is culturally appropriate advocacy at the point of assessment, and not just after you end up in hospital. Now, I actually spoke on that to a psychiatrist congress a couple of months ago, and that had really, I think, quite mixed reactions, and I think to some extent generational reactions. So I think older psychiatrists, but if I'm going to generalize, older psychiatrists felt that was more of a threat, and that they were the expert in diagnosis, and they would ask the questions that they needed to, and that people would interfere with the therapeutic rapport. Whereas I think, again, generalised, that younger psychiatrists felt it would actually be quite useful to have someone there to speak for them or find corroboration for issues, because for example, I had a client who his delusion was supposed to be, he was a qualified carpenter, and he's supposed to have delusion that he had a that he got £10,000 worth of work off trustatrader.com from some app, and he was just taken away and not even allowed to find anything. I mean, why someone might think that's delusional from a qualified carpenter is another thing, but having someone there who can say, stop, let's have a look at this, and doing so coming from the same community, from the sharp end of people who face these issues, I think could make an improvement. But also fundamentally, outside of legislation, looking at a different system that doesn't focus on restraint and coercion, and which particularly disproportionately affects people from racialized communities. So if your experience is that you're more likely to get sectioned in for a longer time, seclusion, restraint, and then onto one of these CTOs, then how is that as a method of engagement with those communities? So unless and there is a new project in South London that Professor Seshta Ran is going to be running, that's looking at bringing psychiatric services to the community, and it'd be very interesting to see how that pans out with his research. But for example, it's going to have a community hub, which doesn't mean that they are setting up in a community centre. It means that they're going to be, for example, in a mosque or a church. Elders from those institutions will be trained up in mental health care. They're looking at a sort of a placement within specially trained families for someone who's in crisis, and looking at maybe some of the budget being managed by the community for those services, and also people getting help with the things that really stress them out and cause them to relapse. So, for example, there'll be a housing advisor there, benefits advisor, to help people sort out. So I know, like when I used to manage services in Lambeth, one time the computer went up the creek for housing benefit, and we had so many admissions as a fallout from that, because people had got into debt, got eviction letters, couldn't sort it out, and then ended up having a relapse. So, a fundamental rethink of some of these things, supported by legislation, is what we present.
That sounds great. It sounds really good. It sounds like perfect.
I think they're recruiting for a manager. I'm tempted to apply.
It just sounds brilliant. It sounds like what you would design if you were given a blank sheet.
Yeah. So
that's an optimistic note on which to end, isn't it? I mean, there's that.
Sorry, Stephen, can I just interrupt? This is one. I didn't want to cut Rheian or Stephen off. Can I just say one really quick thing? On procedural stuff and like how the DOL stuff works in relation to Section 72 and Section 73, like hard law. Like Andy asked a question, which is now in the answered section, about whether you can have a DOL case proceeding via adjournments or a deferred conditional discharge. I've copied and pasted a long answer that I was going to read out, but it's much better just there in writing for people that want to see it. But basically, I don't think you can have a deferred conditional discharge, but the reasons are all there. Anyway, that's all I had to say. Sorry, I'll shut up now.
No, that's very helpful. I mean, that's the next thing. If we were not sitting online and we were in Garden Court Chambers, then at this point you would be being taken through to enjoy copious canapes and refreshments. So I shall put a virtual set of those that we had. There we are. This is what you would have won, as they used to say on the 3, 2, 1 or whatever it was. It now being, it's now 6:30. As long as everyone's got time to cut from the answers to the questions, the detailed answer that Roger's just given, I think I was just going to bring this to an end and thank everybody for attending and people for speaking, particularly Roger, and particularly the external speakers that we've got from Mind. It's important to work collaboratively in this area for all sorts of reasons, and thanks very much for giving us a very useful insight that certainly isn't available just from listening to barristers talk on. So thanks very much, Rheian and Alice, for agreeing to speak at this and for your very helpful and practical contributions. So thanks very much, everybody.